This is Earl White, real estate attorney. This video is about whether or not you need an attorney to complete a deed transfer of ownership in New Jersey. A deed transfer might seem simple because it's not a huge amount of pages. However, there are technicalities and legal issues that can arise when the deed transfer has not been handled properly or thought through. Whether technicality or substantial legal issue, I've completed 1,000 deed transfers, and I can tell you that if they are not handled properly, it can create financial headaches, time loss headaches, title ownership headaches in the future when it is not properly considered and handled. This video is going to cover whether or not you need an attorney. If you are not opting to use an attorney, or you're going to try to skip it, then what are the potential consequences of doing that, why it might be in your best interest to hire an attorney. And also we'll touch on an important consideration before hiring an attorney is what are going to be the costs to complete the deed transfer. One common question people are always going to ask before they engage in the deed transfer is whether or not an attorney is required. This question often comes up because certain states require an attorney, like Massachusetts. Other states, attorney probably wouldn't handle it, like Florida. In New Jersey, it is customary to have an attorney handle it, the deed transfer, but it is certainly not a legal requirement. People may ask that question because they'll begin to handle the process on their own. They'll submit incorrect paperwork or paperwork that just wasn't compliant to the county recording office. The county recording office will reject it. And then after going back and forth enough, a lot of times the county will throw their hands up and be like, hey, look, you have to get an attorney. But technically, an attorney is not required for recording. And if you are going to go forward without the attorney, the forms that you're going to need is obviously the deed itself. You'll need to draft that and make sure you have the proper legal description, lot and blocks, prior owner, new owner, reference to the prior deed, and whatever promise, whether it's click claim deed or warranty deed, whatever particular promise you're going to put in the deed. You also need a get rep form properly filled in to make sure you're not going to pay any exit tax. It's called exit tax, but if it's not a New Jersey resident, there may be a tax to be paid. So you want to make sure that form or some that specifies that you're a New Jersey resident or some other exception that's listed, like less than $1,000, primary residence, to make sure those boxes are checked so you don't get the deed rejected or have to pay like a 2% tax withholding because it wasn't filled in properly. The last document you will need is an affidavit of consideration, which is a form downloadable on the state website for New Jersey, and it will ask you to identify if there's a current mortgage, identify what the consideration is, and if you're going to use an exception to get around different costs that may be associated with a deed transfer, it does need to be similar to the deed. It does need to be properly notarized, and you also need to include a tax ID for one of the grantors as part of that form. Now, although an attorney is not required to complete a deed transfer in New Jersey, it is something that may be in your best interest in many circumstances, and that's why oftentimes people will retain an attorney for a deed transfer. First reason is to save time. When people handle deed transfers on their own, there's a technical problem with the documents. These can be many different reasons: incorrect lot and block numbers. There could be missing legal descriptions. There could be incorrectly identified, misspelled names if they don't cross-check the prior deed. There can be improper notarizations or missing notarizations on certain forms where it's required, like the affidavit of consideration and the deed, where it does need to be notarized. And the notary has to make sure they do it in a good ink, list the date, list their notary number. So there can be various things that pop up with these deed transfers. They can waste your time. The reason that may be in your best interest to hire an attorney for a deed transfer is the attorney is going to help you troubleshoot or spot potential title problems that may arise. For example, you may have a spouse that is not on title but has marital interest that should sign the deed. You may be transferring to a person who you suspect could potentially have a lawsuit or judgment, but maybe you didn't think through that, oh, wait, if I transfer with them, that's going to attach to the property. And then this is going to become a title cloud and become a problem. Attorney can also help you think through any financial consequences. Attorney might not be a tax attorney, it may not be an accountant, but the attorney can help spot an issue, for example, loss of a stepped up basis if a person inherits the property versus transferring it to your kids. So maybe your best attorney save time, save money, get out ahead of any title, or at least get an opinion as to any potential title problems that can come up or any significant financial consequences that may come up as a result of this deed transfer. Now, I have done close to 1,000 deed transfers, if not more at this point. And I have seen where it is not handled properly, that there can be title issues and other significant problems where the parties didn't have it handled properly and considered all the different factors that go into it. First, is that if there's an open mortgage. If you are transferring a property with an open mortgage, that mortgage 99% of the time is going to have what's called a due on sale clause. Due on sale clause means that if you transfer any ownership of the property without a legal basis and exemption to that clause, then the lender can call the loan immediately due. And obviously, if you don't pay the loan immediately due, it'll result in foreclosure. So that is a rare occurrence, but particularly for investors that are doing it all the time, this can be something that happens. I have seen it happen where banks have called loans and then people essentially lose all the money they've invested because it was foreclosed. So again, it might be a low probability chance of it getting called due, but something to particularly consider if you are going to engage in this. Now, you can protect yourself here, though. If doctors don't realize, but there are regulations for any Fannie Mae or Freddie Mac backed mortgage where you do have to still get approval, but they cannot deny your approval as long as you go through the steps. So if you use an attorney, they can hopefully point you at these regulations where if the lender is not working with you in this topic, you can point them to those regulations and they will then work with you faster because they know that they have to process this. And not everyone at the bank that you talk to will understand this. So that's one issue that can come up. I've also seen estate problems come up. When you are submitting a deed for recording, the county does not check the estate paperwork. You just submit the deed and they rubber stamp it and they don't even check to see if it was consistent with the will or who the administrator was or if the paperwork even existed, as opposed to a person just thinking their name as an executor or the family's on the same page and they are going to submit a deed recording. So I've seen that happen where deals go into attorney review. We start drafting contracts and then we do them in the title search or just start discussing the estate issues. And then it turns out there was no probate filed. And then the last deed transfer is essentially invalid. And now we're going to have to wait 1 to 2 months to have this probate either reopened or opened for the first time. And this can particularly become an issue if the will that was there had direct descendants, like the property was supposed to go directly to someone, and as opposed to just a general estate. So that's another type of issue that can become complicated here. And like I mentioned earlier, I've seen this plenty of times where the parties have done a deed transfer and not relinquished a marital interest. This can come up with divorces. Just people believe they have a divorce and you were the only one on title. So you got divorced, you're the only one on title. And therefore that spouse's marital interest is now resolved. That is not correct. If you were divorced or if you were divorced and you need a divorce decree to resolve the marital interest and you don't have that divorce decree, then you need to have a deed from your spouse transferring their ownership to you, relinquishing it. So issues like this can become big problems in the future. So when everyone's on good terms and you're doing this deed transfer and everyone's involved, that is the time to have the conveyance done properly to resolve the potential titles in the future, like the ones I've been mentioning, as opposed to waiting till we're getting an attorney review or drafting documents, which then becomes a really stressful time, particularly if we have a closing date coming soon, title searcher has the problem. And then we have to go ask the prior person on title, this might not be involved anymore, to come sign the deed to complete the closing. And guess what? Now that they're involved in this and they see you're selling a property and that you might be making $200,000, $300,000, $400,000, then a lot of times, unfortunately, they will hold up the process and want to be paid something. And you might have no option, right? Because you're paying them $5,000, $10,000 is cheaper than going to litigate with them. So definitely want to get out ahead of those type of issues. Now, if you're considering hiring an attorney to assist with a deed transfer, one of your natural questions is going to be, what is this going to cost me to hire an attorney for a deed transfer? Attorney fees can be really large. They can be hourly. So if this is the first time you're doing it, you're going to want to know this information. Because the deed transfer, if there are relatively defined tasks with a fixed number of pages, then almost always the attorneys are going to do them as a flat fee. The flat fee may range depending on the attorney that you're using, how good they are or how cheap they are, how much they delegate. So typically you're going to see less than $1,000 in a legal fee unless it's a very complicated situation. So it's not going to break the bank in the sense of being $5,000, $10,000. It's going to be more affordable, something most people with an asset of real estate that could be worth $700,000. The legal fee is not going to be overwhelming. The people like everyone wants to save, but it's not going to be this giant legal fee, mostly flat fee under $1,000. There are additional costs. That is the county recording cost. So the county recording cost is, and record all costs relating to recording almost always come in less than $200. It is the money given directly to the county is based on the number of pages that you're submitting with the deed transfer, and that's typically less than $150. The attorney or whoever's handling submission will either do so typically with mail or overnight FedEx, or they may do it using an e-recording service such as Deeds.com or Simplicity, and then there'll be $50, $75 charge depending on the service. So the cost to record the deed typically under $200. The last cost to be aware of, and this can sometimes be the largest cost, is the realty transfer fee. Is a fee that will be paid when there's an open mortgage. So the question then becomes, do you have to pay this realty transfer fee? Because that can get expensive, right? If you have a $500,000 mortgage, now you're talking about $3,000, $4,000. So that's where costs start to get serious for this. And so there are exceptions to that, though. So to be aware of, for example, parent to child is an exception to realty transfer tax. Spouse to spouse is an exception for realty transfer tax. There's exceptions for estate transfers, exceptions for divorce transfers within 90 days of the divorce decree being finalized. And there's several other exceptions there. So you want to make sure that after consideration, you probably list that. Now, say you don't have an exception, you don't want it, but you still don't want to pay realty transfer. Who would want to pay several $1,000s to complete a deed transfer? The issue becomes that couple issues. One is that the person at the county that's recording the deed, they obviously are going to look at the record and they're going to find the mortgage and they're going to bounce your deed if they find a mortgage and there's no mention of it and there's no realty transfer tax being paid on it. So one, you just waste your time and energy and you don't get the deed recorded and you have to go pay it anyway. Two is the one form you have to submit, the affidavit of consideration. The consideration is the open mortgage. There's a box on this form that you need to check if there's an open mortgage or not an open mortgage. And it would frankly be fraud to not check the box correctly. Maybe it gets through the county, or maybe you get audited. In theory, fraud can be addressed. The statute's pretty severe, so low probability event. But I think for most people that want to properly disclose the facts so they know they are safe from legal consequences in the future, then you want to make sure that you pay that realty transfer tax, because you don't want that affidavit of consideration to be with intentional false information.